status of non-compete agreements. Hey everyone, Adam Bergman here, tax attorney and founder of IRA Financial. And on today's Adam Talks, are non-competes going away? Are they dead? Will they be dead? What's going on? So on May 7th, 2024, the FTC, the Federal Trade Commission, they published a final rule that basically bans all non-compete agreements between employers and workers as unfair methods of competition and requires employers to refrain from enforcing most existing non-competes. So I did a podcast on this several months ago, or more actually, 4 or 5 months ago, when there was chatter about non-competes and what was going to happen. And ultimately, the FTC followed suit and promulgated final rules. And this is huge. I mean, anyone that's has a business, small business, anyone that's an executive, salesperson, has probably came across or at least been discussed in a framework of a non-compete. And a non-compete, it means what it means, right? You are restricted after you leave your employment from competing with your former employer. It's usually restricted by geography. There's usually a period of months, maybe it's 6 months, 12 months, 24 months. Could be as simple as, hey, you're a salesperson selling pharmaceuticals in Texas, and you may be restricted from selling pharmaceuticals in Texas for another business. Things like that. And they're pretty mainstream. There's been litigation over the years about the breadth of these. Are they too broad? For example, lawyers, you can't have a non-compete with a lawyer because you basically can't stop them from being a lawyer, right? And some people have taken that position. Well, hey, I'm a salesperson. I sell coffee. That's all I do. How can you restrict me from selling coffee in this geographical area? I live in Maine. I'm not going to move to a different state to exercise my professional skill set. So there has been litigation. Sometimes there's been compromises. Other times the courts have been pro-employer, pro-employee, depending on the scope of these agreements. But what the FTC is basically saying is that, hey, we're going to stop these things. We think it's hurting employees, not employers, but employees. We think it's unfair. It's basically restricting people from earning income. So I'm going to summarize kind of the final rule and go through some concepts and talk about some potential pitfalls and planning opportunities around this. So the final rules basically are prohibiting most non-competes involving workers. They apply to terms and conditions of employment that prohibit a worker, as I mentioned, from basically seeking or accepting work in the U.S. from an operating business. Okay. There's exceptions to the rule, basically for senior executives, folks that make over $155,000 that have non-competes in the past, or anyone before September 4th, 2024, when this rule is expected to go into effect. Although there are a number of cases out there. There's 2 lawsuits seeking a temporary stay. In one case, the U.S. District Court of the Northern District of Texas, the court has indicated it will rule on whether they issue a stay by July 3, 2024. And basically, there's another rule that says if you have non-competes out there to former employees, you got to notify them that those agreements are not going to be worth anything anymore, which is going to be a lot of fun for employers to do. If the stay is not issued by August 1st, 2024, employers should begin planning. This rule will take effect September 4th, the final rule that basically bans non-compete agreements. And again, this is monumental. It's a massive, massive blow to businesses, large and small, who have used this as a way to protect themselves. I mean, let's be honest, right? If you are in a business and you want to protect your clients and the salesperson is leaving and you're worried that salesperson is going to steal your clients, most people have used a non-compete. Now, what about a non-solicitation and non-disclosure? Well, I think if the NDA just talks about prohibiting disclosure, I think you're probably okay. And I think NDAs survive. Obviously, if the NDA goes further and talks about non-competing, that probably would not be permitted. But non-solicitations, I think, is going to be the most interesting area where I can see clever lawyers trying to stick language in there that basically acts like a non-compete, but it's not. And we'll kind of see what the FTC considers. But in a lot of cases, non-solicits probably could be construed as non-competes. Basically, if you look at the expansion definition of non-competes, it most cases could include and involve non-solicitations. So especially if these provisions contained in the non-solicitation agreements are broad enough to be construed as functioning to prevent the worker from seeking or accepting employment. Now, if it's just saying, hey, you can't solicit our existing customers, that's probably okay. But if it goes further and talks about prohibiting them from accepting employment in any way, I think it would be construed as akin to a non-compete and would not be allowed. So not only are they going forward, but they're also going retroactive, which is interesting for anyone that's not a senior executive, which is going to cause a mess to a lot of employers that are going to need to backtrack and kind of find out what's out there. Some of these folks may have non-compete language in non-solicitation agreements, NDA agreements. The FTC is basically saying go back and notify all these people in writing that the non-compete that they may or may not think even exists is non-existent. But again, just like overall, I do get where the FTC is going. I've had some friends that have been part of these and colleagues that have been part of these broad non-competes, and I get why, but they're construed, I think, unfairly and construed in favor of these employers. Like, for example, I have a colleague that sells pension plans, and he basically wasn't able to compete for 2 years in selling pension plans, which he does in a large geographic area where he lives and where all his relationships are. So yeah, he could move to Texas and sell pension plans, but if he did it, in his geographical area or within 100 miles, which is where all those relationships are, he's not allowed to do it. And that impacted him. I mean, he's off that non-compete now, but for that time period, he basically stayed in the pension world, but he wasn't able to do what he loved to do, which is sell. He had to do another administrative job, which rightly or wrongly, that's what the non-compete did. So what the FTC is basically saying is it's not fair to basically stop people from doing what they're good at. And the example is lawyers, right? You can't issue a non-compete to a lawyer basically saying you can't practice law. And maybe that's not a good example because lawyers are licensed in a state. So if you say, hey, yeah, you're leaving your law firm in New York, you can't practice law in New York, that's obviously not right. But since you're only licensed to do that, but what about the situations like I've been selling coffee for 20 years. That's all I know. That's the only job I can get. No one's going to hire me to sell TVs or sell carpets. I know coffee. So to restrict me from working in a company from selling coffee, that may be overbearing and could impact my ability to earn a living. And that's what the FTC is getting at. On the flip side, businesses are saying, hey, we need to protect our business because if we have a senior person or even a salesperson leave that has relationships and have connections to all our suppliers, distributors, and clients, could they potentially go to a competitor or just start their own business and wipe us out and compete against us? And I think that's where the non-solicitation, the non-disclosure agreements are going to have more power and more impact. Basically, not being a full sword, but more of a shield, and offer you not full protection, but a sizable amount of protection from employees just raiding your client base or taking secret sauce or goodwill in your business and offering it to a new business competitor and the like. So that is going to be interesting. We'll know by July, early July, what the court, at least this court in Texas, will decide. If they stay it, great. If they basically agree with the FTC, then yeah, there's non-competes will go away, and that's incredible. I mean, non-competes are such a big part of the relationship between employers and employees, not only on the onboarding and hiring, but also on the exit. Some companies are very, very, very forceful about it, and others aren't. Obviously, if you're in the AI world, that's something that's going to be super, super important for you. And I've heard stories where ChatGPT, for example, have super, super stern non-competes, non-solicitation, where if you do something really bad, you can lose all your vested stock in the company, like a very bad lever where you go to a competitor and actually are sharing information. So they're very, very focused on non-competes for good reason. And I know in other businesses where non-competes are not even an issue. If you go to a competitor, they're not going to force you to sign a non-compete when you onboard. So it's going to be a major difference maker going forward on how employers and employees interact in different industries. But the final rule really broadens, and I wanted to kind of dig into this a little bit. The definition of a non-compete is broadened by this final rule, and it uses the phrase terms and conditions of employment, which is broadened from the phrase contractual term. Okay, so in the proposed rule, it had the idea and concept of a contractual term of employment, and the final rule used terms or conditions of employment. And they basically are expanding the definition of how the non-compete will work. So if you look at the non-compete language, the FTC identified a non-disclosure provision that is written so broadly that it effectively precludes the worker from working in the same position for a new employer, right? Selling coffee. And two, a provision that requires a worker to repay training costs where the repayment is not reasonably related to the cost of the training. And the FTC's expansive definition of non-compete in the final rule indicates that its examples on the proposed rule remain relevant. So again, this idea of preventing further work in that space. They also went on to say that non-solicits probably could be non-competes. And given the examples from the proposed rule, the FTC's expanded definition of non-competes likely extends to clauses that restrain the solicitation of customers if those provisions are broad enough to be construed as functioning to prevent a worker from seeking or accepting employment. Okay, so since non-solicits, they don't prescribe directly a worker from seeking competitive employment, this is something that obviously there could be future litigation. So I can see lawyers trying to work this non-solicitation language and include provisions in the agreement that basically are not non-competes, but basically stop the person from having any opportunity to have any value from his or her experience. Now, I think there is a clear difference between saying you can't go work and sell coffee in South Florida versus you can't take our customers from company A. So I think if the non-solicitation is really a non-solicitation and is drafted concisely and appropriately, I think non-solicitations are still going to be enforced. Same with non-disclosure agreements. But any language in those agreements that talks about in any way preventing someone from getting a job in that same industry is not going to fly, and it could invalidate the agreement. So that's something to keep in mind. Obviously, retroactively, if you've done this in the past and you have non-competes out there, you're going to have to let those folks know. And the exception is if senior executives for existing agreements, not for future agreements. So if you have a non-compete with anyone that made more than $151,164, they're going to grandfather those folks in. But that's only grandfathered in. Those are deemed senior executives. So those people, non-competes are still valid. But going forward, it doesn't matter if they're a senior executive or not. No non-competes. Doesn't matter for who. Even if they're narrowly defined, broadly defined, no non-competes. That's it. Blanket rule. We'll see what that means for non-solicitations, non-disclosure agreements. I do think non-solicitation agreements will become a quasi non-compete. It just obviously won't go to that extreme of basically preventing people from working in that space, but it's going to ultimately, stop them from really taking any value they received from their former employer, which could potentially hurt their chances of gaining employment in the same industry. I don't think so. I think if they just keep it to non-solicitations, non-disclosures, I think that should protect small businesses alike. So I worked in the coffee business 20 years. I know a lot. You should be able to go to a competitor, not a coffee business. You just can't solicitate the clients of your existing company for a period of years. I think that's fair. That still should allow you to be hired and gain employment in a coffee industry because you know how to sell coffee. You just can't go after existing clients. Or a non-disclosure saying, hey, you can't divulge secrets of your former employer, right? You can help your future employer grow and bring clients, but you can't divulge certain information, details you learned from your former employer. So again, I think it's monumental. It's a massive change in how employees and employers interact. But I think with a good non-solicitation agreement, a good NDA agreement, I think businesses could be protected, both small and large. And I get it. I think the FTC's on the right track, because I've seen it impact friends where they literally like can't get a job for a year because all they do is sell in a particular area, and they're basically these non-competes are basically stopping them, and they're not getting paid for it, right? The employer's argument is that, hey, you got extra money because you made you sign this non-compete, but there's no evidence that you actually got more money because you signed a non-compete. I don't even think that's true. Some people, the employers will say that, say, hey, I may have paid you X, but because you signed a non-compete, I'm paying you Y. I think that's rubbish. I think you're going to get paid the same amount. You just weren't going to get hired if you didn't sign the non-compete. And that's the truth. A lot of companies will say, if you don't sign this, you're not getting hired, especially in Silicon Valley and high tech. And so that's going to be interesting. How does this apply to like government contracts? So we'll see. Can you go turn around and work at the US government as a contractor, consultant, turn around and just, work for China? I'm not sure how that's going to work. But we'll see how the courts deem that. But I think most businesses using a good non-solicitation, non-disclosure agreement, I think you can protect yourself. This will allow freer movement of employees, hopefully help the economy, help people find willful employment and do what they're good at, and also protect their former employees. But remember, there's a notice requirement out there for former employees that have NDAs, although non-competes, not NDAs, non-competes. Except there's an exception to be grandfathered in for senior executives who make more than 151,000, but that exception is only for non-competes before September 4th, 2024. After September 4th, 2024, assuming there's no stay in the courts, there's no more non-competes. That's it. I don't care if you have an executive, CEO, CFO, or rank and file employee. You can give them non-solicitations, give them NDAs, no non-competes, which is, a major change in our employer workforce relationship. And I expect there'll be more cases on this. But from an employer standpoint, I think employers are super happy about this. And I think the FTC, is definitely doing what they think is right. So what happens if you fail to comply? What happens? What can the FTC do? Well, if you fail to comply with this rule, they have the authority to impose fines. And if you don't comply, they also can seek an injunction forcing you to comply. So again, this is the government, right? So it's not a criminal thing. They can monetarily make you pay and basically force you to get rid of this non-compete through injunction. So we'll see how the courts, if there's more lawsuits. I expect there will be. There's a few already. I think there'll be more from business organizations, trade groups that they're trying to protect small businesses and even mid to large businesses from having former employees kind of compete. And when I say compete, I mean impact that their former employers in a unfair, negative way. But again, I think a good non-solicitation, non-disclosure agreement will be sufficient to protect existing companies from their former employees. So that's it. Interesting podcast. I promise you, I will update you in either July or September, depending if there's a stay or when the final rule gets promulgated for non-competes. Because again, this touches hundreds of millions of us. Whether we're rank and file employees, salespeople, executives, this is important. We all have had some interaction and involvement with non-competes, whether it's ourselves, spouses, family members. So it's important that we know the rules, and it's important if you have a business that you know what these rules are, not only for the future, but also what your responsibility is to past employees, including these senior executives. So thanks again for listening and for watching on YouTube. Really appreciate it. Definitely subscribe. If you enjoyed the podcast, please give it a good rating so more people could then see it. because the higher these ratings tend to go, the more the algorithms will boost the podcast so more people can listen to it, because this is a subject matter that impacts so many Americans. So thanks again. Appreciate the support. Have a great day, and I'll see everyone again next week. Thanks.